Hi, I'm Rick Harmon. If you're a real estate agent or a broker dealing with inherited property anywhere in California, there are a few things you need to know, and I want to provide you a few insights in the form of a few videos you can use. No legal advice, nothing really technical, but some basic things you can apply in making your life easier for you and your seller. Just because your seller has full IAEA authority to sell a property doesn't mean that things are going to go the way you want. Oh gosh, you need to make sure that the probate attorney has sent out the notice of proposed action. That is the attorney's job. Occasionally you'll have a seller who does not have attorney representation. One way or the other, the notice of proposed action has to go out. This is the transaction you intend to settle on, and this is what's been agreed on, and this is the price, this is the basic terms, and the notice goes out. Now, occasionally you'll have somebody who's not represented by an attorney and they're a sole heir, in which case that noticing might be able to be avoided, but it's going to be the title insurance company who's going to accept whether that's possible or not. Somebody may come along later and say, hey, I got a copy of this notice to sell the property. I am an heir, maybe a small heir, but I don't agree to it. But what happens if somebody doesn't agree with that who is entitled to receive it? Let's say they're an heir. Well, they could object. They could send notice to the court. They could send notice to the attorney or to your client, the executor administrator, and say, hey, I object to the sale under this price and or terms. Or they could just be obstinate to do it because they don't want to see a sale. Perhaps they're even the occupant property. They could even be the baby daddy person who is mildly associated as a relative, but it could still interfere with your sale. So be aware of that. A notice of proposed action, if it's objected to by the right parties, what that could be basically force is a court-confirmed sale. So now you're at a couple of months, basically, it's going to add to your timetable. So the court-confirmed sale now requires a whole new set of circumstances, and now it's going to subject your sale to other potential bidders and your commission too, because there's a whole process for this for setting up, and you can see how this is delineated in other information and courses and all. But I want you to think about this, is that if you are anticipating that there's going to be a problem with parties, you might as well deal with it on the front end. I would strongly consider having a court-confirmed sale determined on the front end. What that will do, even though your client has full power, sometimes it's going to be necessary to protect them, because even with full powers and no court-confirmed sale, your client is now exposed if you sell the property for too low, or the terms are basically challenged later in court. So in order to do this, to get a court confirmation, get a court order that basically where the judge blesses it. So extra time, yes. That's why private professional fiduciaries, people who are in the business of working with administrators and executors and doing this for the courts as well, will normally get a court-confirmed sale in the very beginning, and just to determine they're going to go that route. So that's just a much easier way to go if you think there's going to be any chance of your client, your principal, your executor, administrator, being challenged later. Hey, this is Rick Harmon from closeprobate.com, and I hope you enjoyed this video. If you find it useful, absolutely subscribe to my YouTube channel. And while you're at it, get my weekly blog, Rick's Rants. You can find that at rickharmon.com, and subscribe. It's free. You'll get it weekly.